Out to our event today. We really appreciate it. My name is Natalie and this is Chris, and we're the co-presidents of the Runnymede Society. So the Runnymede Society is a national society. We aim to foster debate in law schools relating to constitutionalism, liberty, and free speech. So we're very excited to have Professor Pardy here today to speak to us about his article from the National Post entitled "The Social Justice Revolution Has Taken the Law Schools. This Won't End Well." The article was written in response to Windsor Law's statement regarding the Gerald Stanley trial. Windsor's post and the ensuing dialogue in national publications created quite a stir here last year, and so it was at that point that Runnymede knew that there was a conversation to be had. Professor Pardy is a former litigator at BLG and now teaches at Queen's Law in the areas of environmental law, property, and tort.
So just before we begin, I just want to read one little passage from Tom Flanagan's book, Persona Non Grata, and it's academic freedom is not just for loudmouth professors seeking to make headlines. It's equally important to students for the quality of their university education. An atmosphere of free inquiry is essential for verifying knowledge and passing it on. Raising questions about accepted truths is integral to the search process, and if those who raise such questions are made targets of reprisals, truth will be the loser. So with that, please join us in welcoming Professor Pardy.
Where is the podium? Yes, very good, thank you.
Right in front of you.
Thanks very much. Thank you, Chris and Natalie and Runnymede Windsor for inviting me here, and thank you all for coming. I didn't enjoy my undergrad, which is years ago now, because it seemed to me that it was full of classes and professors telling me how to see the world. But I loved law school. And I think that's because there was a recognition inside the law school at the time that at bottom, everything was an argument. And so today I want to offer you an argument. You may agree or disagree. I hope you will voice your objections if you have any, that you will ask hard questions, because that's what law school is supposed to be about. Justice is supposed to be blind. You've seen the pictures and the statues. Sometimes she's holding a sword, and sometimes scales, or both. She's not always wearing a blindfold, but she often is. What does it mean that justice should be blind? It means that the same rules and standards apply to everybody, without regard to who they are. Whether they are rich or poor, black or white, male or female, connected or not. It means that laws apply to you regardless of your wealth, regardless of your lineage, regardless of your class, regardless of your race, regardless of your religion, your custom, your pedigree, your parents, your origins. Justice is supposed to be blind. It's not supposed to matter. And law schools used to be schools that taught about the system of justice. Now, I'm not here to tell you that they are not anymore categorically, but more and more today in Canada, they are as likely to be schools of social justice. And that is a very different thing. Social justice is not blind. In fact, social justice demands to know who you are. Whereas justice is about the individual, it's got to be. If justice is blind, then the only choice is to treat people as individuals, because they have no other important characteristics. That's the whole point. But social justice wants to know exactly who you are, so as to measure the degree of justice that you should be entitled to. Social justice is about groups. And that's one of the main differences between justice and social justice. Now you'll hear the phrase equality and diversity a lot, both in law schools and outside it. And those are two important words. But they have completely different meanings in these two contexts. Equality in the world of justice means equal application. And equality in social justice terms means equal outcome. And those two things are incompatible. You cannot have both. You have to choose one. Why? Well, because individuals are all different. And if you apply the same laws and standards to every individual, they will end up in different places, because they're all different. If you insist that everyone end up in the same place, then you must, by definition, apply different rules and standards, because they're all different. Okay? So you have to choose between these things. You either have equal application, or you have equal outcomes, but not both. The idea of justice, if justice is blind, means we are talking about individual responsibility. Responsibility for the actions that you yourself take. And whether you take those actions with a degree of fault, in the form of intent, or negligence, or as the case may be. That's not the criteria in social justice. Social justice is about favoring people or blaming them on the basis of the groups that they belong to. It's not just about you anymore. It's about your line and the things that other people consider that perhaps that line has done or had done to it. Justice is based upon evidence. And upon the evidence given in the courtroom, upon facts drawn by the finder of fact. Based upon a presumption of innocence in a criminal matter, wherein the outcome depends upon proving the facts using evidence beyond a reasonable doubt. In the world of justice, which complainants are to be believed? I suggest that the answer is none of them. None of them. Regardless of the crime, regardless of the seriousness of the crime, whether it be murder, sexual assault, armed robbery, assault with a weapon, shoplifting. All accusers in any of those crimes, the starting point is accusers are not to be believed until and unless the allegations are proven to be true beyond a reasonable doubt. That's where we start. Not so, apparently, in social justice. Social justice tends to be based upon emotional responses and anecdotes. It pretends to be evidence-based, but if you actually read the material that is presented in support of its agenda, they are just as often based upon emotion and anecdotes, storytelling, narrative. There's lunch. And we are told that we must believe the victim. Now, of course, let's just correct that phrase. Of course, in law, we're talking about the law here. In law, there is no victim until there is a conviction. You don't know who a victim is until the matter is done. Yes. Moreover, within this school of thought, it seems to be that believe the victim is a selective thing. Just like you start with groups and you assess the degree to which they are to be blamed or favored based upon a historical record of conquest and oppression, so too with the believe the victim, because it depends very much on who the victim is and what it is they are accusing somebody of and who it is they're accusing. And then we get to the bits of the architecture of the law. And I hope I'm telling you things that you have already encountered in your time at law school. I hope this is not news. I hope you are getting a wide coverage of these questions, because in a way, this is the question that the law is confronting right now. There is a struggle going on. And the struggle is between those who believe in the Western conception of justice and those who think the Western conception of justice is a source of oppression itself. That these ideas, these very ideas, the idea of equal application is itself an oppressive idea. So, we have separation of powers, we have precedent, we have the idea of text. Separation of powers, of course, being the idea that the three branches of the state have distinct and separate jobs to do. The job of the legislature is to make general rules. The job of the executive is to carry their mandate out as given to them in legislation and nothing more. And the job of judges is to apply the law to the particular facts, and that is all. And the two main restraints upon the courts, number one is precedent. Has to be, right, because justice is blind. If you have a result in one kind of case, and the same kind of case comes up, if justice is to be blind, then the same result must follow, because it doesn't matter who the parties are. The same case must produce the same answer. And the other restriction being the text of the law. Because after all, justice is blind. And the combination of these three things demands judicial restraint. In other words, it demands that idea that courts are not there to make the law. Their role is limited, indeed even technical. It is limited to taking the words and applying them to facts. Now, of course, there are inherent ambiguities in facts and sometimes in laws. So that technical approach still requires legal skill. But it is a different kind of proposition altogether than the one on the other side of the ledger. That side of the ledger says something quite different, which is that courts, doing their proper social justice job, are not restrained in these ways. They're not restrained by precedent. You take facts You take cases on their own facts, pretending that there's no correlation between the old case and the new one, which is usually a fiction. We're relying upon policy. Policy as legitimate criteria for making decisions that might vary from the line of cases already in front of them. And in constitutional cases, treating the Constitution as a living tree. That's just code for we'll do what we think is right. Which means you might as well not have a constitution, because the power now is in the courts. You must have these characteristics in the courts if the courts are to do what social justice says, which is to provide an appropriate degree of blame and compensation to you based upon your group identity. This is all identity politics, unfortunately. It's all about your group membership. It's tribal. I was in New Zealand for a while, teaching down there. It was my first academic job. And fairly early on, I found that certain people would come up to me after class and introduce themselves, which was very nice. It was nice to meet the people down there. But there was also a tendency on the part of two groups down there, people who belonged to two groups, or they thought they did anyway, that's the way their identity worked. And to an alien like me, they physically looked and sounded similar. They were the Maori and the Pacific Islanders. And they would come to me when I first arrived, and it would be clear that it was important to them that I know who they were. That they were either Maori or that they weren't. They were Pacific Islander. And they didn't seem to understand when my response was, that's all very nice, great to meet you, pleasure, but I don't care who you are. I don't care who your line is. I don't care where your people come from. It doesn't matter to me. It matters to me not a whit. In the same way that it shouldn't matter to you what my lineage is. You're not going to assess me differently, are you? You're not going to think more or less of me, are you? Aren't we now grown up? Don't we now believe in those words of Martin Luther King, Jr., that we assess people on the content of their character, not on the color of their skin? This does not say that. This says the opposite. Now, I started with two words, equality and diversity. I talked about equality, equal application, equal outcomes. Diversity. They both have a version of diversity. This version, I would call, my own perspective, real diversity, deep diversity, difficult diversity, diversity of thought, diversity of belief. Yes, diversity of custom and background and culture and race, for sure. But it includes the difficult kinds of diversities, which is diversity of thought, belief, custom. This diversity I would call shallow diversity. This is diversity of appearance and conformity of thought. You must all look different and think the same. Here's what you must believe in. You must believe in this. And if you express otherwise, oh boy, the mob is coming for you. This is one of the problems we have today with the discussion that goes on at law schools. I would call this the beginning of the rule of law. Now, of course, people differ about what the details are, about the system of law that conforms to an idea of the rule of law. But at bottom, it is a contrast between the alternative, which is the rule of persons, meaning power in a person to decide the outcome all by themselves. I would call that this. Or, even more so, I would call this the beginning of mob rule. Because you can't be sure that things are being done objectively. Justice here is not blind. They're deciding the outcome based upon things you have no control over. You have control over your own behavior and your own decisions. You can control action and fault. You cannot control where you come from, who your parents are, what your lineage is, what your color is. Those things are supposed to be irrelevant. But on this side, they're not. And if you say they are, then you have spoken badly. Thomas Sowell, the black conservative intellectual, said this. He said, if you professed a belief in the idea that the same rules and standards should apply to everybody, 60 years ago, you would have been called a radical. 30 years ago, a liberal. And today, a racist. The meaning of racist has now changed. It used to mean that you thought race was important, significant. And now it means that you refuse to acknowledge its importance. And so if you criticize this, you will be called a racist. You'll be called a white supremacist. It's the way the dialogue seems to be going these days. Unfortunate, but hard to escape. Now, is it the case that social justice has taken the law schools? Well, you're inside your law school. You know this better than me about this law school. You can decide that for yourself. All I have to go on is what I've heard and the statements the school has made. Let me just read little bits from the statement that no doubt you are familiar with about the Stanley verdict that the school issued last year. I'm just going to take out sentences. Canada has used law to perpetuate violence against Indigenous peoples. As a law school, we strive toward social justice. We take that commitment seriously. It is the architecture of law that must change. That's the beginning of the architecture of the law. We work to support the production of critical scholarship from our faculty and students who will challenge the system. Nothing wrong with challenging the system. Nothing wrong with asking hard questions. Nothing wrong with looking into the architecture of the law and saying, does this work? Is this principle appropriate? Are we on the right track? No problem at all. Problem is that this logic is a rejection of that and does not seem to tolerate the proposition that there might be something valuable in some of these ideas. We do not accept the status quo. Now, if it is the case that social justice has taken over Windsor Law School, it is not the only one. This is not a phenomenon limited to this institution. It is happening at law schools across the country to varying degrees. Some of them are explicit about it, and some of them are not. There is a mixture of professors at each law school who think different things, as the case should be. However, even in that respect, it is getting to be more monolithic than I think it ought to be. For example, a little while ago, I had opportunity to meet with, well, there was a gathering of all the law professors in the country who identified themselves as not social justice adherents, as in, not progressives, as in classical liberals or libertarian inclined or conservative for that matter, gathered all together in one place. There were 4 of us. Now, we might have missed a few. There might be some others lurking in there somewhere. People who don't want to openly acknowledge where they're coming from. And I'm not saying that all the rest of them are firmly in a certain camp and committed to the ideas as I portrayed them. But I think that reflects the monolithic nature of the institution. It didn't used to be that way. It used to be extremely varied. And variation, if I may put it this way, is good for your education. In making this argument to you, I am not saying that you must agree with me. What I am saying is that you need to know, be aware of the central struggle that's going on in the law schools, but also in the law itself. Because I have portrayed this as the architecture, or the beginning of it anyway, of the Western legal tradition, and it is. But it's not a fixed thing, and in fact it is starting to erode, because more and more courts and more legislatures are beginning to agree with this. The Supreme Court of Canada in particular. You can see in various judgments, recent but not just recent judgments, of endorsing some of these ideas. And so I'm not suggesting to you this version of things. I'm not saying this is the law and this is nonsense and you shouldn't hear about this. No. Because this is beginning to affect the way the law is applied and interpreted. But it is equally wrong for you to go through law school just hearing how right this is and how that's not to be entertained. Because that doesn't give you a proper picture of the law world that you will enter into. In my own opinion, this is simplistic. It's emotional. It's conformist, authoritarian. It's fragile because it's not based on very much. And its fragility, I think, is reflected in the fact that when someone like me does come along and say, you know what? The reaction is often not an engagement of the ideas. It is a hostile, you can't say that. How dare you say that? We're going to object to you saying that. I would like to think that that's because if you start to look at it and take it apart and argue about it, my inclination is that this starts to fall apart. It's based upon certain premises that are not very strong. For example, you need to believe in a thing called unconscious bias to believe that this is valid. Unconscious bias is the things that you don't think you believe in, but you actually do. And unconscious bias is itself based upon a test called the implicit association test, the IAT. It asks you to make decisions. It's a psychological test. They put up pictures and you make decisions and reactions based upon the pictures. You know, a white face, a dark face, and so on. And then you associate whether or not you know, what kind of thoughts you have, positive or negative, and so on. And on the basis of that, they try to measure your implicit bias. Even though you think, all that stuff is irrelevant to me, they try and prove otherwise. The thing is that recently, in the past year or two, that test has been debunked. It has been suggested, based upon the review of all the studies that have been done on this test, that it does not actually have any predictive value on how you actually act. In other words, your score on the test does not indicate that you will act in a discriminatory way. And without that link, what do you got? And note that it's very interesting that the whole thing is based upon unconscious bias, which I would argue they've gone to because they've been so unsuccessful at showing actual bias. It's a perfect idea, unconscious bias, because it's unconscious and therefore you can't deny it. It's easy. You have unconscious bias, deny it, well, that just shows it's unconscious. Too bad for you. Baloney. That's cheating. You're just making stuff up. This is also based upon critical theory, critical race theory. Critical race theory is a school of thought that basically characterizes liberalism, and by liberalism I mean the original version of liberalism, the classical liberalism, the idea of liberalism as being liberated, free to do what you want. Liberalism and meritocracy, that is, same rules and standards apply to everybody. Those two ideas as a vehicle for white self-interest, power, and privilege. So the whole idea that we're applying the same rules and standards to everybody, regardless of who they are, is somehow a vehicle for self-interest and making sure that nobody gets ahead. This is Judge Richard Posner. I'm sure you've run into his name before. If you haven't, you will. He wrote this about critical race theory. He said, "What is most arresting about critical race theory is that it turns its back on the Western tradition of rational inquiry, forswearing analysis for narrative. Rather than marshal logical arguments and empirical data, critical race theorists tell stories. Fictional, science-fictional, quasi-fictional, autobiographical, anecdotal, designed to expose the pervasive and debilitating racism of America today." The other term you'll run into is white supremacy. It is the argument that there are inherent features of the system that feature people with white skins. Let's talk a bit about what privilege means in a legal context. We're talking law here. A person has a privilege, I think we can say, if that person has rights in the law that others do not have. And there was a time in our law where there were definitely privileges. So, for example, if men are able to own property and women are not, men are legally privileged. That's no good. If white people can vote and non-white people can't vote, that's a privilege. That's no good. It breaches this core idea that the same rules and standards apply to everybody. So that cannot stand. And if there are circumstances where there is actual legal privilege, they must be wiped out. But the thing is, they have been. They have been wiped out. I challenge you to identify one legal right that exists today that is available only to a certain class of people. Well, of course you can. But it doesn't work in that direction. It works in the other direction. So, for example, this is not a strictly legal one, but it is an institutional one. At my university, when we are hiring new law professors, we put out an ad. The ad finishes with this: Queen's University welcomes applications from women, visible minorities, Aboriginal people, people with disabilities, and LGBTQ persons. Now, apply your standard rules of statutory interpretation. The rule that applies here is the expression of one excludes all others, the expressio unis exclusio alterius, as its fancy name goes, but it really means if you include one, you exclude the other one. Let's restate the end of the ad. Applications are welcome from everyone except straight white males. There's your white male privilege. So I'm suggesting to you that that complaint does not really exist in the law anymore. It did. It did for sure. But that time has passed. And it is because it has passed and because we have these ideas that we've been able to produce a society that is, in fact, the most equal, diverse, open, and free that perhaps the world has ever seen. It is a society that the rest of the world wants to immigrate to for that reason. And it is interesting to me that some of the people who are most opposed to these ideas are immigrants who have escaped societies that are not free, that are not objective, that are not even-handed. They've escaped those to come here, and now they see this, and they say, are you out of your minds? You haven't been where we have been. This is the beginning of trouble. You don't want to go here. Stop it. But so far, they have not been listened to. Oddly enough, in a way, many of the main proponents of this are what I might call strange white people who insist that everything that they have ever done or accomplished in their lives is due to their privilege. Don't know what they mean, but that's what they say. The funny thing is that even though they say they believe that, they don't actually give any of it up. They're quite happy to sacrifice the younger generation to make up for what they perceive to be the unfairness of it all, but no, they don't actually ever sacrifice themselves. If they really thought what they said, I would have thought that the proper thing to do would be to resign. Because after all, you're in a position where you didn't really earn what you have. That's the implication of the claim that they make. But that never happens. So perhaps I'll leave you there. Let's talk. I don't know how freely you think you can talk. I just don't know. I mean, we are recording this. Be aware of that. It will be posted online. So please don't say anything that you don't want the world to hear. Now, of course, they won't see your face. They'll see my face. But still, please keep that in mind. Let's hear what you have to say. Yes, sir.
First of all, thank you very much for coming here today. I appreciate it. I'll make sure I speak on behalf of everything. We appreciate it. My question's in regard to the Living Tree Doctrine.
Yes.
So how do you suggest we interpret the Constitution in order to allow for changes in society? Because, as you know, that came from the person's case, and if we did interpret it in accordance with the Living Tree Doctrine, women would still not be allowed to be senators today.
Well, you see, there's a very interesting assumption in your question. Thank you for the question. It's a very good question. Let's just think about where we were before the charter. Anyway, I know the section you're talking to is not in the charter, but just let's go back to the beginning of the system. The system is based upon an idea, and well, lots of ideas, but one of the main ideas is the idea of legislative supremacy. That's the governing idea. The idea is the people elect a government. The government sits in the House of Commons or the provincial legislature and passes laws with the consent of the people. That's how it worked. This constitutional thing is supposed to be just a sort of last-minute thought, exception, restriction, not the whole game. The Constitution, and in particular the Charter, is not designed to tell us how things are supposed to be. Our legislatures decide that, for all of us, over time. And over time, our opinions change. And we elect different governments with different policies and different agendas and different philosophies. That's the way it's supposed to be. The idea that the Constitution, and the Charter in particular, should be changed over time so as to adjust means this. You've now given the job of adjusting not to the legislature, but to the courts. How often have you read a case where the courts have said, well, you know, Canadian values are. How the hell do they know what Canadian values are? Did they take a poll? Were they elected? Did they run a campaign? I couldn't tell you what Canadian values are because Canada is made up of a whole bunch of individuals. And those individuals have different values. And those values get to be expressed in a broad way and a group way once every 4 years. And other than that, I wouldn't know how to assess what Canadian values are. But courts seem perfectly willing to do that, to jump to the conclusion that Canadian values are their values, and therefore, and since the Constitution is a living tree, they're going to adjust that so as to adjust it to a present. It is a recipe for judicial rule. It usurps legislative supremacy. So, I take your point. Go ahead.
Can I push back a little bit?
Yeah, of course.
All right, so I understand legislative supremacy, and when it comes to amending bills, it's quite easy. If you disagree with what a previous government did, you change it.
Yes.
As you know, amending the Constitution is a little bit more difficult. And so the courts, when they're interpreting it, instead of having the government have to go through the amending formula, they can just, interpret the word persons.
Mm-hmm.
So are you suggesting that every single time the government feels that society has progressed to a certain point, that they should undertake an amendment to the Constitution? Like, what is, in practical terms, how would a government update the Constitution if it's not for the living tree doctrine? And I completely take your point when it comes to judicial activism.
Yeah.
I don't think there's a place for it, but I'm just trying to understand the balance here between total judicial supremacy and then legislative.
Well, let's take the person's case for example, because that's one of the best ones, right? Because I think we probably all agree that everybody should have the vote, right? And it might have been that when the Constitution was drafted, persons was supposed to be men. So what do we do about that? And one of the solution that they used was, well, we're going to call this a living tree and say, well, today persons means this. Okay? The difficulty is when you have a situation where the legislature won't do something, and the courts say, yeah, you must. We're going to reinterpret. That's a different situation than this. Let's say Parliament had said, you know what, we're going to legislate and give everybody the vote, because that's where we're at now. In that circumstance, the Constitution wouldn't have been an obstacle. The court could have said, well, that's a reflection of legislative supremacy. There's nothing in the Constitution that prevents the legislature from doing that. No constitutional problems, go ahead. That's the legislature leading. That's often not what happens. Instead, the legislature says, no way, we're not doing that. And the court says, well, bad on you, because we're now reinterpreting the words of the Constitution or the Charter. We're going to interpret it to mean, now you must do this. Not because the people said so, not because the legislature said so, but because the court said that's where we're at. Totally different. Bad idea. That's what I'm against. Does that help?
It does.
Yeah. Yes, sir.
I just had a question about, you were talking about legislative supremacy and how you believe in it. What about something like returning the majority? So you're
Yes,
saying,
yes.
once every 4 years we have an opportunity to change our government.
Yes.
How, if like you believe in a restrained role for the judiciary, how do we protect that from happening? How do we prevent that from happening?
So my conception of the Constitution and the Charter in particular is that it creates a bulwark against that tyranny of the majority. If you read the Charter as it is drafted, I think you will find in there words that describe a host of negative rights. That is, rights against which the government is not able to infringe. Freedom of speech means no censorship. Freedom of religion means can't interfere, and so on. Right? If the thing was working properly, those rights would be a refuge for everybody against that tyranny. Let's say that the majority said, well, we don't believe people should be able to say X. And the legislature says, you know, we were elected by those people, we're going to pass a law that says you can't say X. Well, the Charter says, sorry folks, as drafted, the text of the Charter says freedom of expression. So, too bad. I mean, I got no problem with that, because that's interpreting the words of the Constitution, just the way they were intended. The Charter is being reinterpreted. The text describes a roster of negative rights. It's being reinterpreted slowly to consist of positive rights. Rights that entitle you to things, entitle you to be given things, protections that you're entitled to have. My colleagues, some of them, now refer to the Charter and the Constitution as our progressive Constitution. As though, well, of course, the Constitution requires us to be progressive, requires social justice. It does no such thing. That's not the way it's written. It's not what was intended. But because of judicial activism, that's what it is becoming. And that, I think, is a far different thing than what you're talking about. Who's next? Yes.
I was reading one of your articles online about exam accommodation for persons with disabilities.
Yes.
I know there's a bit of controversy with that article. I was hoping you could clarify just so I can understand what exactly you're speaking about.
Okay, I'm happy to do that. We do have a limited time, and I don't want to take away from this topic if anybody else wants to talk about that. So I'm in your hands. What should we do? If I go into that, it's probably going to be the rest of the 10 minutes we have. Or I can talk to you about it afterwards.
Sure.
Okay? Okay. All right. Yes.
I actually find it funny because if the legal system and judges are all racist, I don't understand why they want to crown them kings and queens, but that's beside the point.
Well, it's not really beside the point.
Yeah, I guess not. When would you say, and this is more of a historical question, but what would you point to as the cause of the Supreme Court moving away from originalist or or strict readings of the Constitution and into a more progressive reading of the Constitution? Because certainly, if you look at old rulings, they seem to take it pretty literally, and then we're taking cases now, at least in 1L, where
it is such a good question. It's a great question, and I don't really know. But here's a possibility. It's hard to explain completely about the judges who are now on the Supreme Court, because they're of a certain age, and they went to law school at a certain time. But more and more of the profession, and more of the judiciary, is thinking in ways that's consistent with this. And there may be lots of different reasons, but one of them, I think, is the fault of the law schools. I mean, you can't help. If the content of the curriculum at law schools is this, and I don't mean only this from every professor, I'm not stating that, but if it is predominantly this, then your lawyers are going to think in a certain way about the way the law is supposed to work. And lawyers become judges. So this is not just a problem about law schools. This is not just a 3-year problem for you. If you're finding that things are narrow and restricted and conformist. This affects how your profession behaves. and perfects how the courts behave. What the actual origins of it are in a political, social, cultural sense? Very good question. I think it's a long answer. Yeah.
Okay, so my question is about, it's, for me, how you've laid it out is you've laid them out as pretty mutually exclusive, right? And I think from what we've learned, or at least what I've learned in 1L, social justice was born from the failings of regular justice, right? And it's in the application. I think how you started this was pretty compelling, as though you were blind, right? And that's the main assumption of justice, is that it is applied in a blind way, when in fact, in reality, it isn't. Unless we create like a box in the witness section around the people and their voices are changed and you don't know anything about the background of the witness, justice isn't administered in such a blind way. And kind of more broadly, this to me is just different worldviews that are clashing. This is postmodernism and like Enlightenment rationality. So I don't see them as being mutually exclusive. I think you can criticize the aspects of justice while still not going so far as to, like, I just don't understand why there can't be a centrist approach to this.
Okay, well, so let me say this. It is not my argument that in real courtrooms, dealing with real cases and real people, that there is never a problem. I would never suggest that. I mean, we have a record of wrongful convictions, for example. Those are not satisfactory. That can't be allowed to happen. But my case would be that those problems arise not because of this, but because of the failure to apply these, right? So let's consider the principle. Justice is supposed to be blind. Okay? If you get a courtroom in which it's not, that's a problem. Not because the principle is wrong, but because the people involved are not applying the principle. This throws these principles out. It says the idea of justice being blind is itself the problem. We reject it. We want to know the groups you're attached to. Not just the one group, but the intersectionality of groups. Okay? That's the premise. And so I appreciate your inclination to find a middle ground. And I'm not suggesting this is perfect in execution, not at all. But these ideas are opposite each other. Let me go back to the equal outcomes and the equal application. You can't have both those things. If you try to go down the middle of those two things, those two ideas, you've really got nothing. What is it you're after? Are you applying or trying to apply rules without regard to who they are? Or are you trying to ensure that everybody ends up equally? I mean, those are at least two identifiable ideas. If you're in the middle, what's the idea? What are you trying to do? All you've got left is some vague notion of justice, and that's the worst of all, because now you don't know where your goalposts are. Right?
So I want to thank you for your talk, because a number of times throughout my time at law school, I've heard things in classes that, and there have been feelings that I've had that you spoke about and addressed, so that was amazing to hear. As somebody who's in third year and about to go into the world of articling, and I'm sure other people in this room want to practice and be lawyers in the way that you've suggested, which is looking at the black letter of the law and what justice is about in a traditional sense. How do you suggest making up for some of the lessons you've learned in law school that you may not want to color your future application of the law?
Great question. So, if you think that your ideas have been, the ideas offered to you have been insufficiently broad, then you may have to educate yourself. And in concrete terms, I would recommend that you get hold of a list of good books and make sure you read them, so that you have internalized. This is a system. It has an internal logic to it. It's a beautiful thing. If it's allowed to run, it's a beautiful thing. And it does have this internal logic that you can get to understand and know and get a sixth sense of. And that's what you need to have. Okay? So if you have any notion that you don't have it and you're not getting it, then you must take it into your own hands and read things that are worth reading so as to get that sense of where you're going to. You're going to need that sense. In the real world of lawyering, the real world of lawyering consists of, especially in the first few years, of getting thrown into things that you have no idea about. No idea. And you need that sixth sense to know how the system's supposed to be working behind you so you can go and find out the information you need and fit it in. And if all you have is this, you got no place to go. So get some readings. If you can't find them, let me know. Okay? Yeah.
So like as you recognize that the actual application of justice, like as a system, has some flaws, how do you suggest we fix that?
Whenever the ideas are not followed, you complain. Right? So if you ever have a situation where, just for example, there's lots of examples, where the presumption of innocence is not being followed, well then raise merry hell. Because that's a central proposition. It's one of the characteristics that the whole thing is based on. And if you ever have a situation where somebody is presumed to be guilty until proven innocent, then that's going to result in bad outcomes. Because that's not the way it's designed. Yeah.
But isn't social justice then kind of the mode that you do that through?
Why?
Well, what other, how long?
This mode. So this mode says, here are the ideas. And the problems arise when the ideas are not followed. You're still in here. You don't need any of that. Look, this says presumption of innocence. Here you have a case. This is not observing that idea. That's got to be wrong. Because it's in the architecture. Right? So my inclination, as I said before, is that when things go off the rails, it's not because of these, it's in spite of these. Go back and see what they say. How is it supposed to work? There is an internal logic. It's a system. It has all bits and pieces, but they all fit together. And when they are followed, what you will get is justice. And note this, that justice in this conception is a process. It's a system. It does not dictate outcomes. The outcomes are a result of putting the ideas together. This idea of social justice has content. It says, this must be the outcome, because we think it's right. That's not a process, that's a result. Different thing. Does that help? Yep. Yep.
In terms of how this has sort of manifested itself in the legal profession, we saw last year the Law Society passed, I think, a guideline.
Statement of principles, yes.
A statement of principles. If they were to actually enforce that, could that in any way be found unconstitutional? I only ask because the Law Society is like technically a self-governing body.
Yes. Yes, I hope the answer is yes, but we don't know yet, right? So there is a challenge to its constitutionality.
Yeah.
The matter is ongoing. The problem is that when you challenge these things, you have to go to a court. And you will end up in the Supreme Court, and the Supreme Court has shown itself that it's not here anymore, or not exclusively here anymore. So you can't be sure that these principles will be applied to the case. You're going to get flavors of this, and you can see that in Trinity Western. Trinity Western is a case not based upon the text of the Charter. It's a living tree case, or worse, it's a charter values case. Charter values, where did you find charter values? In the Charter? Actually, no. Not in the words of the Charter. They found them somewhere else. Right? So you can't count now on our courts doing what courts are supposed to do. That's the problem.
I think we're,
Was it out of time?
yeah,
Yeah.
there's a tutorial
We're
in
gonna have
after.
to wrap up.
Okay. Wrap up it.
Okay, so Professor Pardy is not in a rush to leave. If anybody has any questions that weren't answered. I think we're gonna move into the lower commons where some of the seats are. So if you guys have some questions that you wanna ask, then you
I'll
will
stick
make
around.
yourself available.